All right, so in Wisconsin, as soon as someone files for a divorce and notifies the other party properly, either by service or some other manner, generally service, it starts a 120-day mandatory waiting period. So during that waiting period, no court can grant a divorce in Wisconsin. As attorneys, or I'd encourage people who are going through the process on their own, use that time to try to reach an agreement on all issues that you can. Try to make a decision on custody and placement, if you have kids involved, support, property division, get those big issues nailed down and an agreement drafted. Make the required financial disclosures to the court, because just after that 120-day waiting period, it could be a month or so after, but usually around that time period, you'll have your first appearance in front of normally a judge, some counties a court commissioner, and at that time, if you have a full agreement, the court can grant the divorce. If you don't, the process could take longer. On average, in Wisconsin, 6 to 12 months is a good approximation for what you can anticipate a divorce to take. But a lot of that would be county specific, and then even within counties, judge specific on how aggressive they manage their calendars.
It sounds like there's potentially two factors in terms of what's going to increase the length of a divorce. One being the calendars at the courthouse, when you can actually get something scheduled. And then the other one is how well is a negotiation being facilitated during that process in between your court appearances.
Yeah, absolutely. Some divorces are straightforward. If there's not many assets, if parties are getting along with the kids, you could really expect to be done at that first court appearance. But some divorces have so many issues, are so complicated. There's concerns about all sorts of things with the kids or one parent or the other. Those cases will be longer than others, just based on the issues that they're trying to resolve for their family going forward.
Yeah, and it sounds like when there's a lot of issues, you're beholden to the capacity of the court calendar at that point, and you're hoping you can get in front of the judge in a timely manner, but that's not always possible. Can you speak a little bit to that in the counties that you work in?
Yeah, so when I have a case like that has all these complicated issues, whenever we're in front of a judge, it's a critical time. We need to use it effectively. We need to let the court know these are the issues that we're having. These are the questions that we need resolved. This is the information that we don't have yet. You need to go into court, explain to the judge exactly where the disagreements are and what you're asking them to do to help you bridge those gaps, get that information, or to try to hopefully reach a settlement, or in the worst case, be ready for a trial. So that's where a help of an attorney who knows the judges personally, who knows their personalities, what they are looking for in these types of things, it really helps to have an attorney fighting for you through that process, because it's intimidating. You're in front of the judge. It's a different manner of speaking. It's not like this, we're having a nice conversation. That's not really what court is. So it's helpful to have an attorney on your team to make sure that when you do get a window of time with the judge, that it's used effectively.
So where do you get the paperwork to file for a divorce?
All right, so there's a couple different places where you can get those forms. I recommend first start at sterlinglawyers.com. We have all the forms that you need for the divorce available free online. The court system also has them available on their website. And then if those aren't great options for you, the county clerk's office in each county will also have those forms available at some minor cost for copies.
What are the initial forms required for filing for the divorce if you're doing this on your own?
Sure, if you're filing on your own without doing it together with your spouse, you're going to want to file a petition, a summons, confidential petition addendum, which the court keeps sealed because it has some sensitive information on it. And those three documents are all that's required in most counties to get the process started.
Question we get often online is, can I file for divorce by myself?
Absolutely. A lot of people are doing that these days. We refer to them as pro se litigants. And there's some great guides online. There's a lot of helpful information on sterlinglawyers.com especially about the issues that you might face in a divorce. And then there's always options if you want to do this on your own. you can still consult with attorneys. Meet with them for a short amount of time to get advice specific to your situation to help you go through the process on your own as smoothly as you can.
It seems like from online traffic, there's a misconception between how to execute this process, being that you either need an attorney or you have to do it by yourself. Can you talk a little bit about the middle ground in terms of how you can leverage an attorney in a non-litigation stance through the mediation process?
The mediation specifically is if you and your spouse are in a place where you can, on some level, communicate, mediation might be the best fit for you. At Sterling Law Offices, we have some amazing mediators. They're all attorneys who know the counties and the process inside and out. So you and your spouse would sit down with a mediator who wouldn't give either of you specific legal advice one way or another, but can give you helpful guidelines and help you through this process in crafting agreements and drafting paperwork to ensure that you can get through this process in as amicable way as possible and hopefully get your family on the right footing as things change for you.
So as it relates to mediation, what if the let me start over. So as it relates to filing for divorce by yourself, if you don't follow the process correctly with the court, and you show up to court, after you do the initial filing, will the judge? How will the court handle it if you're not properly prepared and you don't follow their process or their guidelines in terms of how you're putting together an agreement?
Well, the court, generally the approach will be at that first appearance in front of the judge. You think you might be done, but the judge has some particular issues. Depends on who you're in front of, but most of the time they'll be understanding and they'll say, well, we can't get it done today, go back and do X, Y, Z. And then next time you're back, which in some counties could be months down the road, we can see if the things are done properly and get this accomplished for you. The judges at that time will probably encourage them to at least consult with an attorney to make really sure that the next time they're back in front of the judge, things are done properly.
Is there any risk of them doing it incorrectly or not following the guidelines and their course will get kicked out of the court and they'll have to start over?
There are some circumstances where the judge's hands will be tied and they can't proceed with the case. Say residency requirements weren't met, service might not have been proper and it's outside of the time window to request an extension. There are circumstances where the judge just can say, hey, there's nothing I can do, I'm going to dismiss this case, go downstairs or down the hallway, refile, and we'll see you after 120 days have passed. It's unfortunate, but it can happen. The judges are going to try to keep the case on their calendar and finalize, but sometimes it's not possible.
Thank you for watching this video. Please like, subscribe, and share. Your interaction with our content is greatly appreciated. Visit sterlinglawyers.com to learn more about our firm and meet our attorneys.